Afternoon. My name is Lindsay Hodgson, and I have the pleasure today and honor of introducing Emmet Bondurant. Emmet is a renowned litigator whose accomplishments and accolades would fill volumes. He has demonstrated a commitment to representing underdogs and speaking up for civil rights throughout his career. Early in his career, Emmet successfully argued before the U.S. Supreme Court, which then ordered the state of Georgia to throw out its maps and redraw those congressional districts to conform to the one-man, one-vote rule. Emmet and his firm are very engaged in gerrymandering litigation, which is currently in the national news. He has served as president of the Atlanta Legal Aid Society, chairman of the National Board of Common Cause, and chairman of the Georgia Public Defender Standards Council, among his many accomplishments. Please join me in welcoming Emmet Bondurant.
Let me address this purely from the legal point of view, which is the focus which we currently have. Common Cause has been for years involved in partisan gerrymandering, having been a co-sponsor of the legislation in California that led to independent redistricting, the same thing in Arizona and a number of other states. We, Georgia, do not have the luxury of having initiative and referendum. Therefore, reform, if it is to come, is either got to come from the legislature by a constitutional amendment, which will require a 2/3 vote in both houses and a ratification by the people, or through the courts. The likelihood that the legislature will reform itself is relatively remote, to put it mildly. Having lived through the reapportionment revolution, those of you who are old enough to know that prior to 1962, districts, congressional, legislative, state senate, did not have to be apportioned equally. Fulton County, which had 556,000 people, had 3 members of the Georgia House of Representatives. Eccles County in 1960 had a population of 1,876 people. It had 1 representative. And this carried throughout the country. And it was only when the courts stepped in 1962 and 3 and 4 and ruled ultimately that 1 person, 1 vote meant that districts had to be apportioned equally, did you have the first reapportionment revolution. That led to the second one, which is that then you gerrymandered districts based on rural and urban, and you did not reapportion. So that if you like the status quo, as many did, they just did not reapportion districts. In Georgia, congressional districts hadn't been reapportioned for 30 years, during which time you had massive population shifts. So currently, the challenge is to find a constitutional way to establish a rule nationally that will ensure fair elections. We're currently involved in the North Carolina litigation. There is also a major case that will be argued in the Supreme Court in late March from Maryland, which is a Democratic gerrymander of a single congressional district. The Democrats essentially took a district that had historically been Republican and chopped it in half. They could have reapportioned by moving 10,000 people. Instead, they moved 360,000 people out, 350,000 new people in, flipped the registration from a 12-point Republican advantage to an 11-point Democratic advantage, and defeated the Republican incumbent who had won in 2010 by 20 percentage points. He lost in 2012 by 24 percentage points. North Carolina is equally bad and perhaps worse. Brian has mentioned the red map strategy. The red map strategy was a calculated strategy by the Republicans to gain control of the legislatures of the states and then gerrymander congressional districts, and thus acquire control for the entire decade of the House of Representatives, which they have succeeded in doing. One of their target states was North Carolina, North Carolina was a 50-50 state. During the prior decade, the North Carolina congressional delegation had changed hands 4 out of 5 elections. Twice it was 7 Republicans and 6 Democrats. Twice it was 6 Republicans and 7 Democrats, and then in one other election it was 8 Democrats and 5 Republicans. When the Republicans took control, they basically brought down a gerrymandering expert from the Republican National Committee who used Maptitude, which is something we can all learn about, to gerrymander the districts to create a 10-3 Republican majority in a state that is 50-50. So that if you took 51% of the vote in the state, if you were a Democrat, you know how many seats you'd win? 3. If you're a Republican and you took 51% of the votes, you would win 10. So that was challenged and held invalid on racial grounds, and then the Republican legislature came back and said, okay, you court told us we couldn't use race, so this time we won't use the N-word. We will adopt standards to maintain the 10-3 Republican advantage, and that's what they did. Well, this was again challenged, but this time on different grounds. And these are the issues that are before the Supreme Court and are going to decide whether we're going to have rape, murder, and pillage for the next century, or whether we're going to reform gerrymandering as we reformed the one person, one vote rule almost 60 years ago. There is the First Amendment of the Constitution, and this is a theory espoused by Justice Kennedy 15 years ago in a concurring opinion, in which he said, all these prior cases have been brought as equal protection cases. In future cases, litigants would be better advised to bring them under the First Amendment, because the First Amendment protects, among other things, free speech, but also the right to vote, and the right to join a political party, and the right to support a candidate of your choice without being penalized or rewarded one way or the other by governmental units. And what you have in a partisan gerrymander is what is called viewpoint discrimination. That is, the party in power favors the people who vote for it and disfavors the people who don't by marginalizing them, by putting them in districts in which they will be outvoted, and so forth. That is the basis for the challenge in Maryland to the congressional district, which will be heard in March. The courts have upheld the theory in part, but in that particular case, the lower court refused to grant an injunction. In the case we tried in North Carolina, we brought it quite differently in part. It is a First Amendment case in which we simply say partisan gerrymandering is viewpoint discrimination, well-established Supreme Court law. You don't have to make up any new law, any new rules, any other things. Says that viewpoint discrimination is per se unconstitutional. And that's the end of the discussion. You cannot use people's political beliefs to sort them as if they were cards to stack the political deck and rig the election one way or the other. But there are other theories there that are interesting and perhaps equally utilitarian. North Carolina is congressional districts, and congressional districts are governed by Article 1 of the Constitution in 2 respects. One is Article 1, Section 2 says, members of the House of Representatives will be elected by the people. And it was on that basis that the Supreme Court in 1964 in Westbury against Sanders ruled that one person, one vote was required in congressional districts, not because of the Equal Protection Clause, but because Article 1, Section 2 said the people would do the electing. And when legislators don't redistrict, guess who's deciding who's going to be elected? It is the legislature, not the people. But there's also an equally interesting theory that nobody had litigated before, including the Article 1, Section 2 theory, which is under the Elections Clause, Article 1, Section 4. The election clause says, and you all can recite it by heart, the times, places, and manner of election of members of the House of Representatives should be determined by the states, by the legislatures thereof. But Congress reserves the power to make or alter these regulations. The Supreme Court, in 2 cases that nobody bothers reading, has said the elections clause is a delegation to the states of the power to determine the procedural rules for congressional elections, not substantive rules, procedure, and does not include the power to dictate electoral outcomes, to favor or disfavor a class of candidates, or to violate other provisions of the Constitution. What clearer example could you have of favoring or disfavoring a class of candidates than a partisan gerrymandering, in which the legislators are essentially dictating whether a Democrat or a Republican will be elected from this particular district. And thus, those theories were before the court in North Carolina when we tried the case in October. And in January, they came out with a 204-page opinion that will compete with Encyclopedia Britannica being comprehensive on the subject. But it is a textbook about how to challenge legally partisan gerrymandering successfully. The court makes very detailed findings, but essentially hold that the North Carolina districts violated the First Amendment, violated the Equal Protection Clause of the 14th Amendment, violated Article 1, Section 2 by having the legislature dictate the outcome in Article 1, Section 4. That decision is now being appealed to the Supreme Court by the state. The Supreme Court has temporarily stayed the case. Well, it will be heard this term. We've got a motion to expedite it. But each of those 4 theories is, in my not very humble view, clearly sound from an academic and legal point of view. There is no persuasive answer. The state had no persuasive answer in those cases. And thus the Supreme Court is going to be squarely presented in a perfect test case setting with the 4 comprehensive theories on which they can rule out partisan gerrymandering. The significance of this can't be understated, but let me give you the Georgia statistics just so we'll bring this home. And I think I can do it from memory, but instead I'll cheat and look at my note. First, let's take Congress. 216 elections were the least competitive elections in the United States since the Cook Political Report has been keeping statistics. Out of 435 House races, only 33 were deemed competitive. That is, decided by margins, and this ain't competitive, of less than 10%. 33 out of 435. 402, or 92%, weren't competitive. That broke down 85 races were decided by margins of 10 to 20%. 256, more than half, were decided by more than 20%. And 59 races did not even have a general election opponent because they were so gerrymandered. Well, let's talk about Georgia. We are the most gerrymandered state in the country. We got to lead at something. In 214, our congressional districts, we have 14 congressional districts. You know how many even had a general election opponent? Only 7 in 214. In 216, 5 did not have a general election opponent. And let's turn to the state legislature. You know, we turn to the mountains from which cometh our help, said the Lord, and all that sort of thing. 80% of state house and senate districts in 216 did not have a general election opponent. 80%. 147 out of 180 house districts had no general election opponent. In 214, the same thing was true in 216. In state senate districts, 41 out of 56 had no general election opponent in 2014, and it went up to 43 out of 56 in 2016. So the legislature's self-interest obviously is self-preservation, and I agree with Brian, a good deal of it is incumbent protection. No legislator was ever elected from a district that they thought was unfairly drawn or should be drawn to be more competitive. That's probably not a surprise. But we have the opportunity, and frankly the Supreme Court of the U.S. has the opportunity this year to set down rules as they did in 1962, 3, and 4 in the one-person, one-vote cases to try to end constitutionally partisan gerrymandering for the entire country, both for state legislative and congressional districts. Whether they'll take that opportunity, the court is ideologically split. The key vote, of course, is always Justice Kennedy, although Justice Breyer is a bit of a March hare who may run in various directions at different times. But the Maryland case, which will be argued in March, offers that opportunity. The North Carolina case, which is even more comprehensive, offers that opportunity. The Wisconsin case, about which you've heard so much back in the fall, is really an equal protection case based on a theory which has both some legal and some factual problems. So there's every reason to be optimistic. I think that the Supreme Court ultimately, when confronted with the facts, will do the right thing. Brian is also right that, unfortunately, the Democratic Party has organized this committee headed by the former Attorney General to work on gerrymandering. I've tried to get them to join by supporting the litigation to end gerrymandering. Instead, they're working on a strategy to duplicate as a blue map strategy the red map strategy that the Republicans had. The Republican red map strategy is already underway for 2020. They have set a goal of a mere $130 million with which to influence state elections. That compares to $37 million, which they spent to take over state legislatures in 2010. So this is a fight that we're all in, that we need citizen participation in. It is one in which the groups who organized in Georgia have done a marvelous job in bringing that issue to public attention. But you are faced with a legislature whose members are in non-contested districts and who have not the slightest interest in what is good for the public welfare as distinguished from their political careers. And that is the problem with partisan gerrymandering. And to quote the right wing of the Supreme Court, in McCutcheon against Federal Election Commission, none other than John Roberts, when talking about campaign finance control, but it's really more true in redistricting, says legislators ought to be the very last people you put in charge of drawing their own districts. I'll be delighted to answer questions later. This is not supposed to be a law school class, and there won't be an exam afterwards.